Representative, it sounds like there is some appetite for further discussion on this bill. So if folks could reach out offline as well and have conversations about the bill, I think that would be helpful. Do we have any other members seeking to be recognized with a question? Seeing no further debate, Representative Buckner moves that House Bill 5449 do pass. Is there leave or partisan? Partisan leave being granted on a vote of 13 votes in favor, 7 opposed, 0 with no position. House Bill 5449 is declared passed and will be favorably reported to the House floor. Thank you, Representative.
Thank you so much.
And I think that brings us to House Bill 5284. Representative Morris is recognized to present whenever you're ready, Rep.
Hello, Chair Gigi and spokesperson Ugrasky. Did I say your name right? Did I pronounce? Okay. And members of the committee, I am here today to present House Bill 5284, which aims to protect those who suffer from severe perimenopause and menopause symptoms in the workplace. I want to thank you for giving me the opportunity to present this bill on such short notice. I am currently working on an amendment to this bill. It was filed yesterday on this bill because I had some concerns, and also your concerns were changing the heading, and that's done. So I am committing to holding this bill on second. Menopause is something that nearly every woman will experience in her life, but we have not taken the steps to make sure that those women are protected. Hot flashes, weakened bones, brain fogs, and insomnia are just a handful of the symptoms that women face. These symptoms are greatly impact a woman's quality of life and ability to show up 100% every day. It's time Illinois takes the steps towards protecting women. I respectfully ask for your vote. And this bill came about from me as a woman, because right now it's hot, and it's important that we talk about menopause because it's not talked about and also in the workplace. And I just want the men to know it's men on pause, right? And it's going to help you guys to know when you're at home with your wife or your girlfriend and they go into it, so you know to go to your man cave and turn on the air or the air conditioner, give us space, because this is real. Okay. Yes, and it's really real.
I would just add that I think with respect to your opening statement, this is something that literally every woman will experience in their lifetime. And so I thank you for bringing this forward and giving us the opportunity to talk about it. I think we just want to note for the record before we move to questions and testimony that there is opposition from the Illinois State Medical Society. It's my understanding that you have a forthcoming amendment. In addition, I expressed some concern about creating a protected class, because I think it's really more a form of gender or age discrimination as opposed to a separate human rights violation that is distinct. So it's my understanding that you'll be bringing it back, removing references to the Illinois Human Rights Act, and then also addressing the concerns of the State Med Society.
Correct. Those concerns are already addressed. The amendment just ain't come back in time. And I didn't have enough time to print it out to give everyone a copy, but that's already done. So I'll be back to answer any questions that you might have.
Thank you so much. Then we'll go to questions from members unless you have additional testimony to provide.
It's hot.
Okay, then we will go to spokesperson Ugasty for a question.
So just for the sponsor real quick, I know you said it, Chairwoman, but you're definitely coming back here with the amendment though, right? You're going to hold on a second, but come back here, not go right to the floor, correct?
I'm coming back here because we want to talk about it.
Then we're good. Thank you.
All right.
Thank you, Representative. Then, seeing no further debate, Representative Tarver moves that House Bill 5284 do pass. Is there leave or partisan? Partisan leave being granted. There being 13 votes in favor, 7 opposed, 0 with no position. House Bill 5284 is declared passed and will be favorably reported to the House floor. Thanks, Rep.
Thank you.
Next up, we have House Bill 4359. The chair recognizes Representative Grassi to present whenever you're ready. And while we're waiting for you to approach, I'll note for the record on House Bill 4359, we have 546 proponents. Representative Sample includes Asis Lira with the AIDS Foundation of Chicago, David Eldridge with the Illinois State Bar Association, Aisha Davis with the ACLU of Illinois, Carolyn Walskog with Youth Outlook, Connie Moody with the Illinois Public Health Association, Elizabeth Ricks with the Chicago House and Social Services Agency, Michael Stone with Center for Disability and Elder Law, Mike Ziri with Planned Parenthood Illinois Action, Peter Contos with Cannabis Equity Illinois, and Spokes Ugassi may have waived to read the remaining individuals. I do see 10 opponents to this bill, which include Casey Pedersen with the Illinois Department of Public Health, David Curtin with the Illinois Family Institute, Jason Speaks with Leading Age Illinois, and Kimberly Stroger with Healthcare Council of Illinois. And so I would just, I know that this is a bill that you've been working incredibly hard on. If you could just, before you present, indicate whether or not you are committing to holding the bill on second and coming back with an amendment that addresses opposition.
Thank you, Chair John Gershowitz and committee members. Yes, I commit. We have been working very hard with those in opposition. We actually have a number of changes that will be included in the amendment that we would ask for a yes vote with the commitment to bring back the amendment to you.
Great. Then please proceed with testimony.
Thank you so much. I am here to present House Bill 4359, the LGBTQ plus and HIV long-term care Bill of Rights. And I just want to start by saying this issue is deeply personal to me. I began my work as a hospice chaplain during the AIDS crisis. And I witnessed firsthand the fear, isolation, and discrimination that so many in the LGBTQ plus community endured at the end of their lives. And I sat with people who were denied dignity, who were treated differently, and who too often faced their final days without the respect that every human being deserves. Those who should have made this difficult time easier actually often made it worse. And so that's why this is deeply personal to me. And I will say clearly that this, unfortunately, is not just history. I continue to witness discrimination and a refusal of dignity and care even today in my continued work as a hospice chaplain. And this is why this legislation is here today before you and why it is so important. As Illinois' population ages, more LGBTQ plus older adults and people aging with HIV are entering long-term care settings. That is the truth and reality. And this bill would ensure that no one is denied care or mistreated because of who they are, who they love, or their health status. At its core, this is simply about health care that provides dignity and respect to all human beings who call a skilled care facility their home. HB 4359 strengthens existing protections, creates a clear path to address discrimination, and ensures staff are trained to provide affirming, culturally responsive care. Just want to give a little bit of information because I think all of this is important. Over 122,000 LGBTQ plus Illinoisans age 50 and older live in our state. Nearly half of Illinoisans living with HIV are over the age of 50, and that number continues to grow. And many LGBTQ plus older adults are more likely to rely on institutional care because they may not have the traditional support or caregiving options available to them. And too many still delay care or avoid care out of fear of discrimination, and that too is the truth. So this bill, I just want to say, enshrines protections, prohibits long-term care, home-based care, and assisted living facilities from discriminating based on sexual orientation, gender identity or expression, or HIV status, and it provides a clear pathway through the Department of Human Rights for residents to report and address discrimination. It ensures staff are equipped to provide care that is respectful, affirming, and culturally responsive. This is really about people being able to age without fear. It's about ensuring no one has to hide who they are to receive the needed care and health care that they need. And it's about also learning from our painful history that I have seen and witnessed up close, and recognizing that for too many it is still a present reality. And it is about really making clear that in Illinois, dignity is not conditional. So I just want to share that we have had good, thoughtful conversations with all the stakeholders about their concerns and opposition, and we do have an amendment that is addressing the majority of these issues. And I'm asking, as I said, for your yes vote today with the commitment that we will hold this bill on second and return with this amendment. I want to say that this legislation, it really builds on existing Illinois law and makes these protections real in the places where people are the most vulnerable. It ensures that every person, regardless of who they are, can age with dignity, safety, and respect. Thank you. And I do have with me Aces Leary's from, what is your actual AIDS? It's Foundation Chicago. Foundation Chicago, if there are any questions or just with some additional comments.
Thank you. Do we have members seeking to be recognized with questions? Representative Didich.
Thank you. Thank you, Representative Grassley. We've had some very good conversations about this bill. I support everything you're trying to do. There's just one particular part, and I know you're coming back with an amendment, so maybe this will be responsive to that. And this may be just some of my ignorance, but help explain to me. So Section 15, there's some disclosure prohibitions. Right, it prohibits disclosure of sex assigned at birth, gender transition status, HIV status, congenital medical verifiable differences in sex development. To me, and this is coming, I may be wrong, and if I'm wrong, tell me why. Some of these seem pretty relevant to people's medical treatment. So, for example, this will apply to some patients who are not able to communicate, right? How does these prohibitions of disclosure intersect with, for example, right, we want, if somebody's HIV positive, I think we want their medical providers to know that they're HIV, right? So how do we make sure that information flows in a way that we want it to, and that we're not putting undue prohibitions on making sure people are getting the medical care that they need? Does that make sense, what I'm asking?
Thank you, Rep. Didich. It does make sense, and I do understand. And as one who has worked in both the hospital and hospice setting in various facilities, I understand that, and it is a medically necessary piece to have that medical information about a diagnosis. Part of the issue and concern is that very often people access this specific medical information, especially with issues like HIV status, where people, those who need to know in the professional healthcare setting do know, but sometimes it's really acknowledging the fact that sometimes this information is shared inappropriately with people who do not need to know.
Right, so as you're working through your amendment,
Yes.
it may be prudent just to clarify that we're not prohibiting doctors from talking to doctors, doctors talking to nurses, stuff like that.
Thank you, and we will definitely address that. And I hear exactly what you're saying. That's a good point, and sometimes information it's shared that doesn't need to be shared. So thank you.
Do we have other members seeking to be recognized with questions on this? And I'll just note that it is coming back, so we'll have an opportunity to fully debate the amendment when it's back before committee. But with that, do we have additional questions from members? Seeing for no further debate, Representative Canty moves that House Bill 4359 do pass. Is there leave or partisan? Partisan leave being granted. There being 13 votes in favor, 7 votes opposed, 0 voting present. House Bill 4359 is declared passed and will be favorably reported to the House floor.
Thank you, committee.
Thank you, Representative. And Leader Buckner, you are recognized to present on House Bill 2563 whenever you're ready.
Thank you, Madam Chair, and thank you, committee, for obliging me this afternoon. HB 2563, as amended, does a couple of things. Under this bill, associations with major shared components or significant infrastructure must conduct and update a reserve study every 5 years. That includes the kinds of things people actually rely on in their daily lives: structural, mechanical, electrical, and plumbing systems, as well as lighting, hardscape, ponds, pools, water features, accessory buildings, when the restoration of or replacement cost exceeds $10,000. This bill does not tell a condo or a homeowners association what it must spend. It does not mandate a special assessment. It does not force a board to fully fund reserves at a particular percentage. What it does require is that the boards and the owners have a real picture of looming capital needs instead of guessing, deferring, or pretending the bill will never come due. The reserve study must identify the major components, estimate their useful life and remaining useful life, estimate repair or replacement costs, and estimate the annual reserve amount necessary to prepare for that work. The bill is also careful about timing and flexibility. If an association already completed a reserve study on or after January 1st of 2024, it has to update it within 5 years and every 5 years after that. If it has not done one, it has until January 1st, 2028 to complete the initial study. The study must be done using qualified expertise, but it does not require a single outside vendor or consultant to do the whole thing. This bill expressly allows an association to prepare the study internally, which is important for the price conversation, so as long as it compiles information from qualified persons or entities. It also strengthens transparency for buyers. In a resale, the most recent reserve study must be made available to the prospective purchaser upon request. And importantly, the bill exempts associations with 15 or fewer units from the reserve study requirement, while still requiring boards to comply with other budgeting and reserve obligations. The amendment, we talked about that already, the amendment makes the condominium side cleaner and more direct by adding section 18.13 to the Condominium Property Act. In other words, it makes sure that this reserve study framework applies clearly and expressly in the condo context as well. I am happy to answer any questions.
Thank you, Leader. I just want to note for the record, on witness slips, we have 9 proponents, which include Ally Lopsher with the American Cancer, no, sorry, wrong. Deadline week, sorry, or brain fog, maybe. Okay. Let's see. Apologies. House Bill 2563. On House Bill 2563, I do see 10 proponents, Leader. They include Brian Butler with the Community Associations Institute, David Eldridge with the Illinois State Bar Association, and Jeff Dixon with the Community Associations Institute. Not seeing any opposition, 0 with no position. And spokes may have leave to waive the reading of the remaining individual proponents. Leader, does this have an amendment, or is this bill final? This is the bill.
This is the bill.
Okay. Then do we have members seeking to be recognized with a question? Representative Reich.
Again, does this just deal with associations that are established as condominiums, or does it deal with other types of associations?
Yeah, so the initial bill was a little narrower, but the amendment brings in all associations, including the ones that you're worried about.
Attaboy. Thank you.
Vice Chair Canty is recognized for a question.
Leader Buckner, it's more of a statement. I just want to thank you for bringing this forward. I've had members of my community reach out asking me to support this very measure, and I'm proud to do so. Thank you.
Thank you, Representative.
Clerk, I am in receipt of a replacement letter from Speaker Welch replacing permanent member Jones with temporary member Morgan. And please add Morgan to the roll. Okay, if there are no additional questions, oh, sorry, spokesperson Ugasti.
To the sponsor, just so we understand, The bill is, as initially drafted, the amendment is not being adopted as part of the
The
bill?
amendment is being adopted.
Oh, the amendment is being adopted.
Yes, sir.
Was it adopted when we got started?
Leader, I think you would need to refile it as a floor amendment. I don't have the amendment posted to committee in order to adopt it.
Got it. Okay. Yeah, and so I will do that, and that amendment, and the only changes in that amendment is that it broadens the scope to make it clear that it's not just the HOAs, but condo associations, townhomes, and everybody that fits into that category.
Okay, so it just makes it more expansive. That's what this amendment does?
Yes, sir.
Okay, that's what I thought, and that's what we were, okay,
Yep.
thank you.
Okay, if there's no further questions, Vice Chair Canty moves that House Bill 2563 do pass. Is there leave or partisan?
We're okay with leave, knowing what the amendment's going to be, and we will vote for that way.
Leave being granted on a vote of 20 votes in favor, 0 opposed, 0 voting present. House Bill 2563 is declared passed and will be favorably reported to the House floor. Thanks, Leader. Okay, the chair recognizes Representative Brielle to present on House Bill 4461 whenever you're ready.
Hello, Madam Chair and members of the committee. Thank you so much for hearing HB 4461. This is a fairly simple bill amending the Fair Patient Billing Act. There is an amendment coming to this bill, so I would like to ask for us to hold on a second, and I will bring it back with the amendment. And what it does is it prohibits non-for-profit hospital networks from placing liens on primary residents. And that is the amendment.
Thank you, Representative. Before we go to questions or additional testimony, I just want to note for the record that we have 9 proponents, which include Ali Lapsher with the American Cancer Society Action Network, Ariel Hernandez with the National Nurses Organizing Committee of Illinois, and spokes may have waived to read the rest of the individual slips in support. I see that Dave Gross with the Illinois Health and Hospital Association has slipped with no position. It is my understanding that you do have a forthcoming amendment. And are you committing to bring the bill back to committee to talk about the amendment when it's in front of us?
And it was due to your suggestion. So the current bill also it did not specify additional property. And you mentioned it does make a lot of sense that if someone has additional property, that should be able to have a lien put on, but not the primary residence. So that's what
Yeah, I think what we talked about, just for the record, is that the intent of the bill is to protect somebody's primary residence, their homestead, not
Exactly.
necessarily investment properties. And so we just wanted to make that clarification that's consistent with your intent.
Yes, thank you.
Okay. Then we will go to questions from members. Are there members seeking to be recognized with a question? Spokesperson Ugasti.
Again, I know you addressed it, Chairwoman, but I wasn't certain. You're committing to bringing it back? the amendment.
Absolutely,
Okay, thank you.
100%. Yeah, thank you. It's actually being drafted, it just hasn't been kicked out yet.
Vice Chair Canty, do you have a question?
I do not have a question. We thank you for bringing this forward. We also have a yellow sheet up here, if you can pick it up after you leave the table. Thank you.
Yay.
Okay, do we have anyone else seeking to be recognized on this bill or recognized for a question? Thank you so much for bringing this forward. There being no further debate, Representative Didich moves that House Bill 4461 do pass. Is there leave or partisan? Partisan leave being granted, there being 13 votes in favor, 7 votes opposed, 0 voting present. House Bill 4461 is declared passed and will be favorably reported to the House floor. Thank you, Rep. We're just going to stand at ease for a second. Clerk, I am in receipt of a replacement letter replacing permanent member Tarver for temporary member Avalar. And can you please add Avalar to the roll?
Thank you.
Okay, I think that brings us to House Bill 5179. Representative Stava is recognized to present whenever you're ready. And I apologize for the wait, Representative. It's deadline week, and we're trying to make sure we have enough members here.
Yes, thank you. No, I understand. Thank you so much, Madam Chair and members of the committee, for hearing this important bill today. The bill that I am talking about, 5179, talks about some of our most sensitive personal data, our thoughts inside our heads that can be measured through electrical impulses in our brains. There's a number of consumer devices that have proliferated on the market. A good example of this is like a wearable meditation device that I know one of my constituents owns. And when he bought this device, I'm sure what he didn't know is that the reason why he didn't have to agree to any consent is because we don't actually require any consent for collecting and storing neural data in the state of Illinois, which is the electrical impulses. Again, why should we care if they have our electrical impulses, you might say? Well, currently there is thought-to-text technology that can predict with about 40% accuracy what you were thinking at the time that you were using said device. So I am certain that when my constituent bought his meditation device and used it, he did not conceive that some company could own this data forever, sell this data to whomever, and that is the current state of our laws. And you might say, well, why doesn't BIPA cover this? This sounds like a biometric process. Scientifically, it's not. Scientifically, the electrical impulses do not meet the criteria for biometric information the way that we have it defined. Last year, I introduced a bill to expand the definition of BIPA, which is a lot of feedback that I heard on this bill that I'm presenting today as an alternate approach. You'll note the committee did not hear this bill last year. We had to take a new approach to create a standalone bill to make sure that it's clean. And we also are addressing one concern, at least one concern with an amendment that's planned. So that concern that was brought to me that seemed very doable and easy to do was to exclude data centers from liability here. And that's just when they're hosting the third-party data. So the liability would stop at the company that owns the meditation device. It wouldn't then go on to you can sue the cloud company that's storing your neural data. Does that make sense? So the liability would stick with the company who was the bad actor, is another way of saying that. So currently we have no neural data protection laws in our state. Colorado was the first state to pass neural data protection laws just a couple years back. I happen to know a neuroscientist in my personal life, and that's how this bill came across my docket. I am not a neuroscientist, nor do I pretend to be one. So I brought some with me today. So they should be able to answer any of your technical questions, give you more examples of devices that are on the market. I will also note that Apple has a patent to do to take essentially EEGs, electric impulses from your brain, in their next set of AirPods. So it behooves us to take action on this issue and not sit on it for another couple of years. Thank you.
Representative, it's my understanding that you did have some witnesses here seeking to be recognized with testimony. I do see 2 proponent slips on House Bill 5179, and those include Ashley Collins and C's Pasowski, and I apologize if I have pronounced that name incorrectly, with the Neuro Rights Foundation. Do we have witnesses that are on the Zoom that are
Yes.
seeking to be recognized?
Yes, we do. I believe
Okay.
Sean and Ashley are both there.
Okay, with your introduction, I don't know which of your witnesses you wanted to go first, but they are recognized to present if they would just please state their name for the record.
Sure. Sean, you can go first.
Hi there. Can you hear me?
We can hear you. Just please state your name and the organization you are here testifying on behalf for the record, or if it's yourself, let us know that too.
Yes. Well, just thank you so much, Chair Gon Gershowitz and members of the committee. Thank you for the opportunity to speak today and for your leadership in taking up this important issue. My name is Sean Pasowski, and I'm a practicing neurologist. I'm the medical director at the Neuro Rights Foundation, and I work at the intersection of clinical neuroscience, health policy, and emerging neurotechnology. And I also serve in organized medicine, where I've been involved in developing policy on neurotechnologies and neural data. And I'm here today in strong support of House Bill 5179. We are entering a moment where technologies that measure and interpret signals from the human nervous system are rapidly moving out of research and into labs and everyday life. Consumer devices can already detect patterns of attention, fatigue, stress, and other cognitive states using medical-grade technology. This information, what we call neural data, is not hypothetical. It's being generated right now and at scale. And as the representative mentioned, it's just going to increase exponentially here in the coming years. And neural data is different. It is not simply another form of personal information, and it is not adequately captured by existing categories like traditional biometrics. Neural data is derived directly from the functioning of the brain and nervous system. It has the potential, even today, to reveal aspects of a person's mental state, and in the near future, it will become even more powerful. And for that reason, it deserves a tailored framework. House Bill 5179 does exactly that. It establishes clear expectations that individuals are informed, that consent is explicit, and that people retain the ability to withdraw that consent and have their data deleted. These are not barriers to innovation, they are the foundations of trust. That said, I would offer one constructive suggestion as the bill moves forward or in the future. and that would be aligning the definition of neural data with the definition adopted by the American Medical Association, which would help with clarity and consistency across jurisdictions. In particular, adding a clause to the current definition that delineates neural data as not including data inferred from non-neural information would reflect both scientific and medical reality and emerging policy consensus. Neural data is not information collected, for example, by biosensors such as an Apple Watch or facial or voice recognition or other wearable health technology, which deserve separate protections. And so that alignment can strengthen the bill while preserving its intent. And it was supported by the Illinois State Medical Society when the AMA adopted that policy. But furthermore, and importantly, this bill focuses on non-medical context where consumer technology is advancing more quickly than existing regulatory structures. That is where the greatest risk currently lies, not in clinical care, which is already governed by established safeguards, but in everyday environments where sensitive neural data may be collected without clear protections. From a clinical perspective, I can tell you that patients and families already assume that information about their brain and mind is among the most private categories of data. If we fail to meet that expectation, we risk undermining trust, not only in technology, which can collect such medical grade data, but in the broader systems that rely on it. Illinois has long been a national leader in privacy through BIPA, and with House Bill 5179, you have the opportunity to lead once again, this time in recognizing that neural data represents a new frontier, one that requires thoughtful, proactive governance. This bill strikes that balance. It protects individuals while allowing innovation to move forward responsibly. And thank you again for your leadership, and I'd be happy to answer any questions.
Thank you. Representative, do you have another witness that's seeking to be recognized to provide testimony, or just here to answer questions?
I think just here to answer questions.
Great. So thank you for that. I thought there was some, I learned a lot, and I think there was some helpful suggestions as well about aligning the definition of neural data to the AMA. I know the Attorney General's office may want to weigh in here. Are you committing to bringing the bill back on second reading with an amendment that addresses any concerns?
Yes, and I'd be happy to do the updated language on the AMA definition.
Okay, so I just wanted to open up for members' questions. This is an incredibly novel topic, and so I think we're trying to learn and understand exactly what is encompassed by the bill. So do we have members seeking to be recognized with questions? Representative Divich.
Thank you for bringing this bill. I just want to ask a few questions about the enforceability of this bill. Could you walk through how this will be enforced?
So it was modeled after BIPA, so the enforcement mechanism is suing the company that's the bad actor, collecting data in ways they shouldn't, and or selling data in ways they shouldn't.
So this is 5179, is that correct? So I just want to, section 20 is what I'm looking at. It says the Attorney General and the state's attorneys are authorized to enforce the bill. Could you just give us a sense of the feedback you've gotten from the Attorney General and the state's attorneys on whether they believe this is enforceable?
Well, we have been in close conversation with the Attorney General's office since we started drafting the bill. And in fact, we were going to put this into PIPA. They were strongly opposed to that. So I don't know that I don't remember a specific discussion that I was present for that discussed exactly what you're asking, but I am certain that if they still had that issue that like we don't want to be enforcement mechanisms of this, they definitely would have reached out to me.
I'm just hesitant to pass a bill that
they did not file opposition.
I mean, do we, maybe it might be helpful if we invite them to give feedback on the enforceability of this, or I just want to, I mean, there's some like specific things that I've identified that I have some concerns about on the enforceability, but I'm also not the expert on that. So before we give this big project to our agency, you know, I just want to make sure they're comfortable.
It's my understanding that this mirrors the BIPA process.
I don't think that's correct.
And so if that's incorrect, then I'm happy to amend it to more closely follow what PIPA does.
So I'll give you an example, right? And this is just one like kind of particular example. Like there's a provision that says a third party that receives the instruction to like delete the data must promptly comply with that instruction. There's criminal penalties to this. So like in a criminal context, what does the word promptly mean? At what point does criminal penalties trigger versus at what point have they not failed to promptly delete the data? Like that's one like particular example that like I'm trying to think through, like how do we know when someone's conduct shifts from non-criminal to criminal conduct?
Sean, did you have any thoughts on that?
Well, what I can speak to is that, in the first bill that we passed in the state of Colorado, where I live, that our Attorney General's office was involved and supportive from day one, have testified, and our law passed, I think, in April of 2024, and went into effect in August of 2024. And I have not heard any concerns from them regarding the enforceability or had really any feedback about difficulties with that. So I know there's precedent for it. As far as the details, I'm happy to look into it and get back to you.
So I think my request would be, right, because we're in a deadline week, so I want to be respectful of everyone's time and what's feasible over the next 2 weeks. Is the commitment to come back, is that contingent on the support of the Attorney General and the state's attorneys that they're comfortable enforcing this?
I certainly wouldn't come back with something the Attorney Generals were opposed to. And the state's attorney.
Maybe I'll see if there's I'll let other people on the committee maybe weigh in if they want to.
I guess I was saying yes to you, so I would want their agreement.
Representative Vella is recognized for a question.
So that is, this gets to the crux of my question. Is this, do you consider this a criminal matter or a civil matter or both? I mean, are you looking to put people in jail? Are you looking to fine them? Are you looking to, what are you looking to do here?
We're looking to fine them at a minimum.
So possibly put people in jail for this?
I apologize. I am not familiar with the portion of the Section 20 clause that is what triggers the potential of a criminal case. Sean, did you have any thoughts on where that language came from?
Not being a legal expert, I don't know that I can comment robustly on that portion. But what I can speak to is that in prior versions of this, that it's been rolled into a broader Privacy Act. For example, the Colorado Privacy Act was amended to include definitions of neural data. The California Privacy Act was amended to include definitions of neural data that came with all of that same enforceability. So, well, again, I'm not a legal expert. My assumption is that those clauses are coming from language from, bills with a precedent for sort of broad privacy acts of that nature. But again, I'm a doctor, so that's just my speculation.
So I guess my issue is, so my understanding is it's potentially a Class A misdemeanor, which is eligible up to a year in jail. And it triggers not just when you collect it, but if you fail to delete after you've been, consent's been revoked, there's no way of knowing how consent, I mean, it looks like this is a criminal and a civil penalty, but a lot of the kind of, I come from a criminal perspective, a lot of the criminal stuff's not there. Like, what's the state of mind? How do you prove this? If, for instance, if consent is revoked, what's the mechanism for that? Who enforces it? It sounds like the Attorney General has to do that. So we're putting a pretty big new burden on the Attorney General. And I understand they have not weighed in. I'm just not sure if they knew about this. So I'm hesitant.
They have been informed along the way of what the content of the bill is.
Okay.
So
And they knew about
suggesting otherwise would be inaccurate.
They knew about the criminal aspects of it?
They have reviewed the up-to-date bill that we filed, yes.
Representative,
And I think one of the things that we're contending with here is like, how much should we punish a person that steals or misuses our most vulnerable data? And I think we need both to have the firmest consequences. Certainly, if the committee disagrees, we can think about an amendment to change that, but I am committed to bring an amendment back and to further discussions with the committee members.
Representative, I think that the issue that we have here is twofold. One, in order to meet constitutional responsibilities for a bill that has criminal penalties, you have to at least have, I mean, it is just a constitutional requirement to have a mens rea outlined in the bill. What amount of knowledge is needed before a criminal liability would attach? I'm not even sure that you can put criminal penalties and civil penalties in the same bill. I think that may actually violate statutory construction principles. This bill, I think, as it's written, I wanted to give it the opportunity to understand and to enlighten the committee about what neural data is, the importance of this conversation. I think you've brought something really important in terms of our ability to understand this new frontier in terms of the amount of data that's out there that we ought to consider protecting. I think the question is how. I'm concerned that you might not have the votes to pass the bill out of committee today, so I'm wondering if you're wanting to move to a roll call vote, Representative, or do you want to take this under advisement and continue to work on the bill and maybe come back with something?
I have continued to work on the bill. I have committed to continue to work on the bill while I'm holding the bill on second. Not calling this for a roll call vote would mean that I've basically given up on all of these constituents who are not just my constituents, who are all of our constituents, whose personal data is currently being stored and able to be sold without any sort of protection. So I think that if people want to vote against their constituents' privacy, I have committed to work to the extent possible to make sure it is upheld and constitutional. There is nothing more I can say. I would like a roll call vote.
Clerk, can we please add, oh, I'm sorry, I'm in receipt of a replacement letter from Speaker Welch, replacing permanent member Buckner with temporary member Kelly Cassidy, and can you please add Representative Cassidy to the roll? Representative Delgado, I think, wanted to be recognized for a question.
So I like you, I'm not an expert in this area, right? So let me ask a couple of questions, and I think maybe your witness might be able to help me understand better what this data is, right? So you talk about neural data, and I can think about BIPA because I understand that like in a contextual way because that's been around for a while and I've seen it operate and I understand how that works. How would a consumer who has utilized this technology and maybe has, let's say they withdraw their consent, how would they then know that they have been harmed in some way in order for them to bring forth a claim? So if we're talking about the civil liability option, like Can you maybe help me understand how that would work in practice?
Well, I think in terms of how it works in practice is how a lot of ways we discover laws are broken is it's not just happening to one person. It's happening to a whole host of people. And there will be artifacts from those events that people say, delete your data. If you can still log in, you should be able to see whether your data was deleted or not. There should be protective safeguards in place. And again, if a company is going to be a bad actor, they're likely going to be a bad actor. But hopefully with this law in place, they'll think twice before engaging in that type of behavior. So I think in the best case scenario, this is a preventative law that prevents companies from even thinking about doing that because they put the procedures in place because we have this law. Does that make sense?
Yes, but I'm not sure that it gets to the crux of my question, which is, so how does this operate in Colorado? Has anybody brought suit in Colorado? Have we seen it actually in action? Are there some examples that maybe you could share or your witness could share about how this is working in practice?
Yeah, Sean, I'll let you take that one.
Yeah, so as far as the spirit of the law, as Representative Stava has mentioned, it's a very forward-looking position where we don't want to wait until there is something analogous to, say, some of the data breaches that we've seen regarding, for example, social media data or bank data. I mean, this is just adding neural data. If you think your bank data is sensitive, or if you think that your address or things that are covered by these broad privacy acts are sensitive, we're just saying that neural data should be included with the same protections. So my understanding, again, I'm not a legal expert, but that these broad privacy acts do have thresholds as far as number of units sold in a state before the law takes effect. So I think that number is 25,000 in Colorado. So as Representative Stava mentioned, the first, broad consumer neurotechnology products are just starting to be sold. She mentioned the AirPod, which I can show you. I've got this isn't the actual product, but this is going to have a brain sensor in it within the next couple of years. So it's really a proactive step to ensure that breaches of the brain do not happen. What could be worse than an advertiser, for example, not only knowing what's going on in your brain, but for example, what health condition that you have, and start to advertise to you based on this health condition that you may not even know that you have. There are 40 million people who have anxiety. There are 1 million people who have epilepsy. It's those kind of scenarios that we're trying to avoid.
I apologize. I know we could probably explore this topic for a very long time because it is so new and we have so much to learn. Given that if this bill were to have the requisite number of votes to pass, it would have to come back anyway, because the folks on this committee are lawyers, right? So it's not just about the goal of the bill. It's, does it meet the constitutional scrutiny that's required for a criminal penalty? Is it enforceable and implementable by the Attorney General? Representative, I don't know that you're going to have the votes to pass this. So do you want to table it or do you want to go to a roll call vote?
I'd like to go to a roll call vote.
Okay. Then clerk, please call a roll. Oh, I'm sorry. Just want to make sure, for the record, do we have any additional members seeking to be recognized with a question before we go to a roll call vote? Representative Cassidy is recognized.
With all the back and forth about enforceability, I would like to hear from the Attorney General's office about their feelings about it.
It looks like we do have somebody here from the Attorney General's office who could weigh in. Just please state your name for the record.
Of course, and I'll fill out a witness slip as well. Steve Walsh, Illinois Attorney General's office. There's been a lot of discussion about enforceability here today. It highlights some significant problems sticking the criminal component of this enforcement with civil penalties. Our original recommendation was not to amend PIPA, the Personal Identity Protection Act, we would like to see it, we think it's more appropriate to be in BIPA, where you have clear remedies, clear enforcement laid out. Another issue that we've told both staff and I believe the sponsor is that the bill gives us rulemaking authority. We don't do rulemaking authority. That's not our agency. So that is a concern as well. And then I guess there would be some other, we would like to see enforcement drafted in a much different way to be more consistent with statutory code.
Thank you. And would you just commit to filling out a witness slip when you have the opportunity?
Absolutely.
Okay. Given that this is a novel, and we are having ongoing discussions about data privacy, different types of new technologies in the AI working group, I'm wondering if this might be a better subject matter for that discussion as well. But I think we do we have anyone else seeking to be recognized with a question on this bill? Leader Williams is recognized.
Rep, I appreciate your work in the privacy space, and you brought this up to me a while ago when we were talking about BIPA, which I feel so strongly about, and that's the protection of biometric data. My question to you is, you wanted a roll call vote. You characterize it as if you vote no, you're not for protecting this sort of data. I don't think that's an accurate characterization. I think when I did a little bit of research on this bill, and there are other states have different approaches, but there are some pitfalls because it's a new and an unusual thing. And maybe throwing it in BIPA is a better approach, or maybe a tighter version of this. This is quite a big change. So I would ask that you would consider working on it without moving it to second. It's hard to vote on something that you feel is unenforceable. As attorneys, we try to stay away from that. So I would just push back on the idea that a no means we don't believe in this issue or we don't care about this issue, and say that we just think maybe a different approach before we embark on something very new and very different. I'd ask you to consider that my health data privacy bill is in 3 years in the works, and we still haven't got it done, and everybody knows what we're talking about there. It's just a more complicated issue, and I think I myself understand the concept, what you're going for, believe in privacy rights strongly, but would maybe ask you to consider maybe a different approach or slowing it down to make sure we get it right.
I'm not sure how a vote today changes the timeline of anything because I'm going to have to reintroduce something next year anyway or get a shell bill. So I'm willing to hear the roll. I'd like to know where people are at. It's helpful to me to understand who this is important to also. Thank you.
Okay, do we have anyone else seeking to provide testimony or be recognized for a question? There being no further debate, Representative Delgado moves that House Bill 5179 do pass. Clerk, can you please call the roll?
Gongershowitz?
No.
Canty? No. Ugaste? No. Davis? Delgado?
So I'm going to vote no as well, but I do want to make it clear that I think this is an important issue and that we do need to figure out how we address it. Government often is not on the cutting edge of some of this stuff because we take a moment to try to and get the enforcement piece of this right. And so while, Representative, I agree with you, this is a very important thing that we should be taking up, I just don't think that we're quite where we need to be yet.
Didich? No. Freeze? No. Fritz? Hoffman? Yes. Jimenez?
Yes, and I would also just like to thank the sponsor for bringing us some new enlightening information. Like many of us, I am not an expert, but I learned a lot today and would like to see the work continue. So I want to vote yes to just give the sponsor some support to continue the work. And I think, want to ask the sponsor not to give up, even though, what today may not be the outcome that you desired. I want you to make sure to continue to work on this to protect the privacy of all of our constituents. And, if I can be of any of assistance, please let me know. But I also acknowledge that, a lot of really great questions were put out there, especially around enforcement. I would not like to see a criminal side enforcement, but I do want to see a more BIPA-like enforcement. And I feel like there's a pathway there. So I'd love to see you continue to work on this. Thank you.